Hello and welcome to Topic 10, Lecture 2. And in this lecture, we are going to be learning about the legal rights during trial. So, what are we going to be covering in this lecture? Well, we're first going to look at criminal trials and democracy and the important role that due process plays in a democracy. Then we're going to learn about the trial rights and the United States Constitution, where we find the trial rights in the Constitution. And so we'll be learning about the Fifth Amendment, the Sixth Amendment, and the 14th Amendment. And so that's what we're going to cover in lecture. I'm going to leave it to you to read about the actual trial process in your textbook. So that's what we've got in the docket. Let's go ahead and get started. So it's easy to try and convict a person in an authoritarian governmental system. Keep in mind that an authoritarian government is the type of government that recognizes no legal limits on its power. So if a government has no legal limits on its power, it can basically do what it wants. And we talked about this when we were talking about policing, how it's easy to arrest people in an authoritarian government because police don't have rules that are limiting and guiding their conduct. And the same is true with trial and conviction. And so that if a government has no legal limit, it will, basically, it could charge somebody with a crime without probable cause. It could try somebody without a jury, or if the jury could be corrupt or the judge could be corrupt and non-impartial. The government has no legal limits and the accused has no trial rights, right? So the accused doesn't have a right to bring witnesses. The accused maybe doesn't even have a right to be present at their trial. The accused doesn't have a right to a speedy trial. The accused could just be held for years pending trial. So, I mean, obviously, that when you think about an authoritarian regime and the trial system, that it basically conviction in an authoritarian regime it's a joke. It's a complete sham. Anyone could be found guilty or anybody could be acquitted, and it has absolutely nothing to do with justice. And so it's obviously harder to convict a person in a democracy, as it should be, because in a democracy, the government can't do whatever it wants. It has clear legal limits on its power. And so that the government can't charge whoever they want. They've got to have probable cause. The evidence that they use needs to be collected in a legal and constitutional manner. They can't hold somebody and not try them for years and years and years. They're bound to, provide a speedy trial. And they can't stack the deck against the criminally accused for the most part, right? If the criminally accused wants a jury trial and they're eligible for it, then they will get a jury trial, and that jury will be selected in an impartial manner. And so the government has clear legal limits, and the accused has robust trial rights. They have the right to a jury, an impartial jury. They have the right to the defense, even if they cannot afford it. They have the right to bring people to, testify in their defense. And so all of these are things that we're going to be learning about as we are learning about the trial rights is outlined in the Sixth Amendment. So conviction in a democracy is much less hollow than it is in an authoritarian regime. But, clearly it's far from perfect. We know that even though the criminally accused have robust trial rights, there's a lot of pressure, particularly on those who are poor and minorities, and bail is set and they can't make bail. That there's pressure for them to waive their trial rights, right? To engage in a plea bargain. We know that only 10% of cases go to trial. So oftentimes the accused, particularly those who are poor and minorities, have to fight for those trial rights, that they're like the courtroom work group trying to get it through the system as quickly as possible. And there might be pressure to, accept a plea agreement, right? So yes, it's harder to convict somebody in a democracy, but as we all know, it's far from perfect. So because we live in a constitutional democracy, where the limits on the government are clearly outlined in law and in the Constitution, where we find the trial rights are, for the most part, in the United States Constitution. And so where we find trial rights are in several places. that you find trial rights in the United States Constitution in the Fifth and the 14th Amendment, and then also in the Sixth Amendment. And so let's take a look at these amendments and then dig into aspects of the amendments in more details. One of the cornerstone principles of criminal justice in the United States is the concept of due process. And this is something that we've talked about throughout the course of this semester, particularly as it relates to the due process perspective that we learned about earlier in the semester. So, as we've mentioned before, that due process is the assurance that all levels of American government must operate within the law and provide fair procedures, okay? And so if you remember too, we talked earlier this semester about procedural criminal law, right? That there's substantive criminal law, but there's also procedural criminal law. And procedural criminal law is due process. It's the kind of criminal law that outlines the fair procedures that agents and actors within the criminal justice system must abide by. And there's a constitutional mandate for due process, and it is found in the Fifth Amendment and in the 14th Amendment. It was initially found in the Fifth Amendment because initially the Bill of Rights was the first through the 10th Amendment, and that the Fifth Amendment was seen as only applying to the federal government, not to the states. And so in the Fifth Amendment, there's the Due Process Clause, and it's the federal Due Process Clause. And it basically says that no person shall be deprived of life, liberty, or property without due process of law, okay? And so basically what that means is that if the government is going to take away your life, liberty, or property, and those are all things that can happen in a criminal trial, and your property can be taken away in a civil trial, that the government can do that, but they must follow and operate within the law and within fair procedures. In other words, the government is not above the law; it's not below the law, right? That that fair procedure is there, and the government must follow it. Now, following the Civil War in 1868, the 14th Amendment was added to the Constitution. And in the 14th Amendment, there's a due process clause in the 14th Amendment as well. And this is the due process clause that applies to the states. And so there is a comprehensive due process mandate in the Constitution for both the federal government and the state government. The reason that the due process clause was added in with the 14th Amendment is that because there was a lot of concern that coming out of the Civil War, the newly freed enslaved people, that they would that the southern states would try to deprive these newly freed enslaved people of their life, liberty, and property. And so they added that into the 14th Amendment that said that not just, the Fifth Amendment is telling the federal government that they can't take away your life, liberty, or property without due process of law. The 14th Amendment is saying that the states can't do that either, that no state shall deprive any person of life, liberty, or property without the due process of law. In other words, due process, important cornerstone of criminal justice in the United States, and all kind of justice in the United States, that it is a constitutional guarantee. There's another part of the Fifth Amendment that is also related to the trial rights in the United States, and that is, I think, pleading the Fifth. We're all very familiar with this. And so that the Fifth Amendment tells you that people who are accused of a crime, they have the right to refuse to testify at their trial. In other words, the government can't force you to testify, okay? You have that choice. It says that no person shall be compelled in any criminal case to be a witness against himself, okay? And so, basically, this is some additional protection that is given to the rights of the criminally accused. In other countries, you can refuse to testify, but the state can actually bring that up and let the jury know that, well, why did that person refuse to testify? What are they trying to hide? So in a way, it can kind of be used against you, thus kind of coercing you subtly to testify. But that's not the case in the United States, right? You do have to say that you're going to plead the Fifth, right? If you are being questioned. But at your own trial, if you do not want to take the witness stand, you are absolutely free to do that. The government cannot compel you to do that. They cannot basically subpoena you. And that brings us to the Sixth Amendment. Now, don't be overwhelmed. We are going to read through the entire Sixth Amendment just because I think it's good to see the Sixth Amendment because there is a lot that's included in it, but it can be a little bit overwhelming. But after we read through it, we'll dig through it so that you have a better understanding of what each of the different provisions within the Sixth Amendment mean. So the Sixth Amendment reads that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So, lots of rights going on in the Sixth Amendment. Why don't we go through, dig through it, and see if we can figure out what each of these provisions in the Sixth Amendment actually mean. Now, before we dig in, I want to just take a look at a couple of questions that I want you to keep in mind as we are going through these different trial rights. For one, I want you to ask, say that when you're learning about these trial rights, I want you to ask yourself, I want you to make a connection between the trial rights and due process. And so ask yourself, how do these rights satisfy the promise of due process, right? So the framers, when they were writing the Bill of Rights and the Sixth Amendment, they were thinking about placing limits on the power of government. And so really sort of think about how do these trial rights achieve these goals of placing limits on the power of government, but also making sure that the trial is going to be a fair procedure. So in other words, how do these rights provide assurances that the trial is going to be fair? Now, I want you to keep in mind that the Sixth Amendment rights are broad and underdefined. You just sort of saw that, that when you look at the Sixth Amendment and it says that the accused has a right to counsel, what exactly does that mean? How has that been interpreted? Well, it's interpreted by the Supreme Court, okay? And so the framers left those words broad and underdefined, and that we turn to the Supreme Court, and we have over our history, we turn to the Supreme Court and law that provides a more robust definition of these rights and procedures, okay? So keep those in mind as we are looking at the specific trial rights. So the Sixth Amendment tells us that the defendant has a right to a speedy and public trial, an impartial judge, and if there's a jury trial, the right to an impartial jury, okay? And so let's talk about each of these. So, and how they relate to due process, to assuring a fair procedure. So when it comes to trials, it's important that the government tries you in a timely manner, right? And that's why it says that there's a speedy trial. Why is that important? Why is that fair procedure? Well, if the government charges you with a crime and then waits a really long time to basically try you, there are a lot of things that can take place. For one, if you are languishing in jail and you're waiting and waiting and waiting, you might just sort of give up and say, forget it, I'll plead guilty, right? And that's not fair. Also, if you are waiting for trial, the evidence could be getting stale, right? The witnesses could lose their memory. The evidence might not be relevant anymore. And so there might be, and that might be good for the government, right? Particularly if there's evidence that would exonerate you. And so there may very well be reasons for the government to drag its feet. And so the Supreme Court has said that the government cannot do that. And because in the Sixth Amendment, it says that you must have a speedy trial for those very reasons. And so speedy isn't defined in the Constitution. It's been interpreted broadly as, depends on what state you live in, but in Wisconsin, that the government must try you for misdemeanors 60 days after your initial appearance and 90 days after after your initial appearance for a felony. because that's seen as enough time for the government to get its case together, but not too much time to basically have an adverse effect or more of an adverse effect on the criminally accused. Now, keep in mind the right to a speedy trial is a right that the criminally accused has. Okay, it's basically telling government it can't drag its feet. But if the criminally accused wants extra time, they can ask for extra time. Now, within reason, right? And so the criminally accused couldn't wait for years and years to have a trial. But that there are times when people are not tried for a year or so because the defense is still trying to get its case together, and based on the judge's sense of that, then they will allow or not allow it. It's important that the trial is public. Why? Because sunlight, the public is sunlight, and the sunlight is a disinfectant. And so people can come in and actually watch what's going on in a courtroom. Then the government, it serves as a check on the power of the government. We see what's going on, and you'll see that when you go to the courtroom. And so trials are public. Doesn't mean that everybody can get in the trial, but it doesn't mean that the media is always going to be allowed into the trial. But there's always going to be some seats that are going to be set aside for the public. You have a right to an impartial judge, even though that's not in the Sixth Amendment. It has been interpolated from the Sixth Amendment by the Supreme Court. They're basically saying there was a case where somebody felt like the judge was against them, was out to get them, and they were convicted. And they appealed and said, look, I didn't have an impartial judge. And they said the Sixth Amendment, even though it's not explicitly stated in there, that is definitely a part of these trial rights. And if you have a jury, you have a right to an impartial jury. Now, you don't, in the criminal cases, you don't always have a right to a jury. You have a right to a trial, but you don't necessarily have a right to a jury trial, okay? And that sometimes you just get a bench trial, which is before a judge. What the Supreme Court has said is that jury trials are reserved for serious cases, and serious cases are defined as any case wherein an individual, if convicted, would serve 6 months or more. So if that's the possible outcome, if you're convicted, then you have the right to a jury. And that, so as it says there, not all offenses have a right to trial, but the more serious offenses. And then that the rules of jury selection assure due process. I'll let you read about those rules. But, in your textbook, you'll learn about voir dire, and the certain challenges that people have when it comes to jury selection. And so just in short, voir is just basically saying, look, we are pulling our jury from a large and representative sample of the place in which that crime took place. And that in, Wisconsin and in most states, it's that jury pool is drawn from a voter registration. I'm sorry, not voter registration, a car license, if you have a license for a car or a state ID. And that's good, because if it were voter registration, right, it wouldn't be representative, because not everybody's registered to vote. And so most everybody has a state ID or a license to drive, and therefore it makes for a more representative sample. Voir dire is the opportunity to question people under oath, jurors under oath. And then based on that questioning, there can be challenges to come up, challenges for cause, like, hey, somebody knows somebody, they know the criminally accused, or they know the police officer, some of the people involved in that, and they'll be kicked off. And the peremptory is that each side just gets a chance to knock off a juror, right? Like, I don't want them, but they don't have to explain why. But you can read more about that in the textbook. But it's this selection, this process that helps assure as close as possible to assuring a fair, representative, and unbiased jury that will sit and listen to your case. Continuing on with trial rights, obviously the individual, the criminally accused, has a right to be competent in trial, and we talked about this earlier. That convicting a person that can't participate in their own defense is unfair, right? I mean, of course, you can convict somebody who is mentally impaired, under the influence of drugs, have a low IQ to the point where they're not able to defend themselves, but that makes a mockery of that. And so you have the right to be competent at a trial at your trial. And generally, that what that means is if the court deems that you're incompetent, the trial will be postponed until treatment is able to render that individual competent. Okay. And I guess if that never can happen, then, well, then there really can't be a trial because it would be a violation of due process. You have a right to be present at trial. Okay. I mean, that makes sense too. If the government says, unfortunately, you can't show up to your trial, you're barred from the trial, then how could you properly defend yourself? You can't. And that makes a mockery. Now, granted, if you come to trial, we actually saw this with the gentleman who participated, who killed people during the Waukesha holiday party a couple of years ago. When he came to trial, he was present. He represented himself, which wasn't a good idea. And he was acting out, right? And the judge sent him out, So, yeah, you have the right to be present at trial, but if you're not following the rules, that you can be kicked out as well. You have the right to confront witnesses. So, the state and that's what's known as the Confrontation Clause, that the state has a right to bring witnesses against you to make their case, but you have absolutely every right to cross-examine the prosecution's witness. If the prosecution just brought witnesses, but you weren't able to poke holes in the testimony that is being leveled against you, that's not fair. That violates due process, right? So defendants get that opportunity, and I mean, defendants themselves aren't going to do that cross-examining for the most part, but their defense attorney will. It also prevents hearsay testimony, and so that it's one thing if you are. That somebody is coming and witnessing against you, saying, well, I saw the criminally accused stab the victim, right? And then you can ask questions about that. But then if they say, well, my best friend told me that the criminally accused stabbed the victim, well, that could come out during that confronting the witnesses. And obviously, hearsay testimony is not allowed. That you also have a right to the compulsory process. And basically what that means is that the criminally accused has a right to subpoena people to come and testify on their behalf. And so they can secure witnesses in your favor. So just think about how unfair it would be if the state could bring their witnesses, but you couldn't bring your witnesses to basically make a case for why you did not commit this crime. And so that is also a part of the Sixth Amendment, that compulsory process. So last but far from least is the right to counsel. And so the Sixth Amendment tells us that the accused has the right to the assistance of counsel for his defense. Well, what does that mean? Okay. Well, we don't know. We initially didn't know what it meant. Like we had said earlier, that a lot of what's in the Constitution and the Bill of Rights is broad and somewhat vague. And so we leave it to the Supreme Court to give us guidance on that. Initially, what it meant was that the poor have a right to counsel in capital offenses. That is where the punishment, if convicted, is the death penalty. Okay. Now, the assistance of counsel, the right of the assistance of counsel, that broadly means that you can bring a defense lawyer to the courtroom, okay? The question really was, though, does that mean that the state has to, provide you with that counsel? If you've got the money, then you can bring a counsel. But does the state have to provide that counsel for you? Now, clearly, when you're thinking about due process, if only those who can afford it can bring counsel, that doesn't seem very fair, okay? And so, that's what the case Powell versus Alabama in 1932 is about. This is about the famous Scottsboro Boys case that looked at a group of African-American young men who are accused of raping a young woman, and that they were tried without counsel or without adequate counsel, and that they were convicted. And so the Supreme Court said that violated the Sixth Amendment's right to the assistance of counsel. But it was very limited. They said that you have a right to counsel only if you're poor, and that you could be found that you could be put to death if convicted. In 1938, that was expanded to say that the poor have a right to counsel in federal offenses, because federal offenses was, a part of the Sixth Amendment. Didn't necessarily apply to the states, and so it extended to federal offenses. And then in 1963, that's when we really begin to have this more robust understanding of the right to the assistance of counsel. The famous case, Gideon versus Wainwright, and that, the documentary, X-credit documentary, Gideon's Army. That's why it's called Gideon's Army, because after Gideon, everybody had a right. Everybody who can't afford an attorney has a right to an attorney. And that's what that was decided in Gideon versus Wainwright, that the poor have a right to counsel in state offenses, okay? And it doesn't have to be a serious offense, okay? That it is that you have a right to counsel if even 1 hour of your life it could be taken from you as a part of the penalty for being convicted. Today, defendants, including juveniles, receive robust rights to counsel. If your freedom can be taken away, you have a right to counsel at trial. You can waive that right if you want, but it's not advised. You can defend yourself pro se, but it's greatly advised against. And then finally, as a part of due process, even though it's not in the Sixth Amendment, that we do know that you have a right to be convicted only if the state proves guilt for each element of the crime, which we learned about earlier in the semester, beyond a reasonable doubt. That doesn't mean with absolute certainty, but it means without a doubt that you feel as if this person has committed the crime. We know that that's a higher bar than in civil trials, and it's a higher bar because more worse things can happen to you if you're convicted. You can be incarcerated, your liberty can be taken away, your life can be taken away if you're convicted of a crime. So we want to be damn sure and very confident that in this democracy, when you are convicted, that you were convicted without doubt, and you still have a chance to appeal. All right, that's it for the rights of the criminally accused that are found in the trial rights that are found in the Sixth and the Fifth Amendment. Thanks for paying attention. I appreciate it, and I will talk to you again soon.